What are the challenges and opportunities that in-house counsel teams face today? This quick-fire session focuses on their challenges and opportunities in the current business and legal environment. The conversation will cover legal and regulatory risks, best practices, and their outlook for the year 2019. And to lead the GCs, we have Preeti Suri. I'll just quickly introduce Preeti, and then she will introduce the panelists. Preeti is very famous. Preeti is the founder and managing partner of PSA Legal Counselors. She's a seasoned lawyer with 30 plus years. I didn't know that. That's good to know. She's the first generational business lawyer who set up and developed the firm. Her global experience provides valuable insights, and she's known for her pragmatic ability to get the deal done. I didn't know that she has been rated by IBLJ as one of India's top 100 lawyers. Wow, that's really nice. Congratulations. And ICCA also listed her amongst top 100 corporate advisors. Preeti, all yours.
Thank you very much. So I will come and stand here for a minute because it's easier for me. Due to height constraints, I can't see people on this side. Yes, I think this is a very, very important panel because largely we are talking to the key decision makers, the guys in the companies who are advising the CEOs and who are very close to the board. So for the purpose of today's discussion, we have three extremely distinguished set of panelists. I will start with the gentleman on the extreme left, John Thaliath. He is currently the GC for GE's Global Research Center, which is also the John F. Welch Technology Center. You have to understand, the background to know where they are coming from, what their experiences are, given the size and scale of the companies also that they are operating in. He has previously held positions at Intel, and he has also been the GC at Tyco Electronics for India, Middle East, and Africa, and also a founding member of the Christ School of Law. I don't know how you find the time to do that, but that's really interesting. On a very interesting piece is that he is, he's an LSE alumni, but he is also a coffee roaster. That's the part I want to discuss with you outside later. To John's right is Satish Kumar. Satish is the global head legal and the chief data protection of Ramco Systems. Within the organization, and to those who know him otherwise, he is the deal maker for the organization, which essentially means that he has the ability to facilitate end results. He has written extensively on various subjects. He is also very, very actively involved on GDPR, open source software, insurance, blockchain, etc. To Satish's right is Amit Chauhan. Amit is currently responsible for the global function of InMobi. InMobi, and I didn't know this, he told me this a short while ago, has a reach of 1.6 billion users worldwide. That's a very, very significant number. He's based out of Bangalore. So we have an extremely stellar group of people who have domestic as well as, who are responsible for domestic as well as global functions. As Probir pointed out at the beginning, the idea for us to focus on this, when Nikhil and I were discussing how we would want to structure this panel, was really to go back to iTech Law 2018, and to see what is the various laws that have come into India, either as laws or a need for Indian companies to focus on complying with other non-Indian laws, the GDPR. So May 2018, the GDPR came into effect. Thereafter, we have a version, our own Indian version, still in draft form of data protection. So I'm going to raise certain questions to the panelists. Each of those questions, I would like you to respond, and let's just keep it very open and sort of lose no particular sequence as such. But, so what I would like to start with as the first question is to see how 2018 has changed legal and the tech space. So we have these new laws, these additional need to comply, and for example, we've also had in this very year the courts ruling in India as well as the regulators on ban on e-pharmacies. Okay, the small and big Indian IT and IT-enabled companies also have to now comply with GDPR as well. So, if you take into account the year that has passed, what would you say are the key takeaways for the tech-enabled businesses? What are the risks? I'm assuming there are risks over here. And how best do you overcome those risks in your organizations? Amit, would you like to start, please?
Thank you, Preeti. Why did you choose me to start?
Okay.
Yeah, that's okay. First of all, thank you everybody for attending this. I know that I'm standing between scotch and,
Wine.
most boring things on the planet, which is data protection, privacy. And since I have an extremely illustrious panel here and everybody out there is, excel in the field of law, so there is no point talking about law. Remembering 2018, I remember a first line of a ghazal from Mehdi Hasan, which says, "Ek sitam aur meri jaan abhi jaan baki hai," which translated into English means, I am still alive, give me one more blow, to the regulatory authorities, that is. I think I heard Justice Chandrachud speak about betting a few years ago, and he said that there are three things which no law ever has been able to regulate: drinking, gambling, and prostitution. I think he missed the fourth one, which is technology. Technology by nature is going to evolve irrespective of what the law says, because technology is something which is so close to making life easy for a human being that technology evolution is going to take place. The only thing we hope is that the government does not over-regulate, and whatever are the laws, they stay as they are and we can live with it, because just as there are innovators in the field of technology, there are innovators in the field of finding a way to do business and also be compliant with laws. I manage a business which is run across, means our services are available in 140 countries and we are present in 17 countries. Every country presents its nuances, so we are used to the challenges of law. But what we like more about certain jurisdictions is that there is more stability in terms of the legislation. For example, the GDPR was announced many years ago and you had time to prepare for it. Of course, data protection and privacy by nature is ambiguous, and so is the law. There is no way that you can have 100% clarity. In fact, the regulators themselves are looking for it to play out and then interpret it. What we want from any regulator around the world is clarity of the law, and the position should stay for some time so that it plays itself out. And I think everything else will follow.
Yeah. And I'll follow. I'll take on from whatever you said. Law is always catching up with technology. Technology will go forward no matter what, and laws will always be playing the catch-up game. But as an in-house counsel at the scale at which we are, we discussed earlier too, and at the risk of sounding a bit snobbish and cocky, a lot of discussions, especially at the opening session on data privacy and things, I was listening in keenly. A lot of issues discussed, our positions most likely would be, as long as the law is clear, we are willing to go and comply. We do fear lack of clarity, but we don't look at anything as business disruptive. As long as it's a level playing field for everybody, me and my competitor, we are willing to go and comply. In fact, maybe it's a scale talking, maybe it's not so much of a disruptor for GE, maybe it's in that middle space where it's disruptive on the business model itself, that the concern is high that whether one would be over-regulated. But within GE, the position always has been, let's get ahead of the law, let's see what we need to comply, let's see how we can practically do that and be ahead of the game. So that's been the general trend.
2018 for Ramco was very critical. We are managing about close to 100 million business, and we are present in more than 20 countries. Our products are available in more than 20 countries. 2018, especially for legal, was a very big year. The role for the legal department has increased, for my team has increased, and for the role for the CEO and the expectation of the privacy law, GDPR, it was very hyper, before May 25th, 2018. And post the rollout, we know that it is on the walls, and we had to face it. The question is whether, we were told that we were one of the first companies which started on the journey of complying with the privacy GDPR law. We were very happy to that, and we set a benchmark, in fact. But it's a journey. It's a big journey for Ramco as far as complying with GDPR is concerned. The challenge in 2018 was not only with GDPR. We also had some problems in on other countries in complying with the laws in other countries, like for example in Australia, Australia Privacy APP, and also in Philippines. So the 2018 byway was a big year where we had to take care of all the privacy requirements. So it was, and it was a direction-setting year for us, and we are growing from there actually.
So would you say that for all of you, from an, in terms of how you have evolved, your organizations have evolved in this year, what I can understand is complying was not been an issue. There is obviously a need to comply and there is a willingness to comply, provided there is certainty in what one has to comply with. Would that be a fair assessment?
Yeah, the need and willingness to comply was there. And what needs to be complied? Yes, that was a big challenge. Every day the business team, the clients had a requirement, whether we need to comply, what needs to be done. The client always had a query for the business team, and the business team always run after us. And we used to take the help of, do our own research and take the help of other councils to frame the regulatory framework for what needs to comply. The willingness was there both from the business team as well as from the internal legal team. But we have to set the direction for the business team where, they can sell it across to the client. That is where, the deal makers, that is where the legal team made the big impact.
In the process of setting up a compliance regime to comply with, be it data privacy or anything else, we don't want to make life difficult for our internal clients. We don't want to make the system so bureaucratic that they have to do more non-core work to be able to achieve their outcome than their core work. So sometimes when there is lack of clarity, the issue is that you build defenses around it and it becomes a bureaucratic process. But generally, yes, the willingness to comply has always been there. Clarity, we seek clarity in the legislation, but legislations by nature cannot define everything. And hence, we have engaged with a lot of councils outside to see what is the best position we can take to put in a regime in place which is easiest for business, yet the best for compliance.
Yeah, that's a win-win situation.
Yeah.
And if the law remains the same, there is no problem. See, there is a cost to compliance and there is an effort to compliance. For example, GDPR is a major overhaul of the IT infrastructure in almost every company. Even the company of the size of GE will have to adjust its data infrastructure. A company of our size will have to do it. Data localization brings about challenges. So one challenge is that, the effort that has to be put into it. The second challenge is that if the law keeps changing all the time, then for certain companies it can become a huge challenge. In fact, I know of a lot of competitors that gave up on Europe as a region because of GDPR. Because they said that the cost benefit analysis of doing business in Europe for say a $50 million business per annum, it's not worth it. Right? So unless you have a sizable business in Europe, you will not do it. The good part of GDPR, which I like about it, is that once you're GDPR compliant, you look at the Indian data protection law and you say it's okay. It doesn't matter, right? That's the same concept, as long as the people who are interpreting it also understand it well. Because if they don't understand it well, then you have a different problem. First you teach them, then you explain it to them, and then you escape them, right? So that should not happen.
Yeah, that's an interesting spin on it. How many legislations, if we consider the tech legislations, what are the legislations in India? How many do we have? Anybody? I think it's time they got their whiskies. So, in essence, we have one statute, which is the Information Technology Act. Okay? And look at the way technology is actually moving. You've got technology that is disrupting practically every area. When I look at my cell phone and I see some of my colleagues using their cell phones, or even friends and family, everything is so app driven. We have only one law, one statute that deals with technology. We have obviously the impact of that coming across if you're dealing with a particular business in healthcare or in food. You've got all the other related regulations. But purely on the tech part of it, there is only one act, one statute with multiple rules that go, rules that have been set in place. What do you see? So do you see purely from interpreting the law, and also your, the challenges that you may have faced if you had in this past year interacted with regulators on the changes that have been brought about in the tech space? Have you had and confronted any challenges, whether in India or outside?
See, I have done it outside India without naming it. But I think the authorities were willing to listen and understand the business, and they were supportive of the business. I don't believe that I will find the same support in India if it happens. That's my experience with almost everything in India. Because we as a society are not very supportive of business, right? Your most favorite son-in-law will come from an established company. He will not come from, if he's an entrepreneur, then the good girls will shy away from him if it's an arranged marriage, right? So we, as a setup, we don't like entrepreneurship. We have that fixated mindset. That is why, for whatever it is worth, I can say this. How many product companies have come out of India? A product which is going to be bought in the United States. We are not good at it. We are great at services. So if I define point A and point B, I have wonderful engineers to take me from point A to point B. But defining what is point A and what is point B does not happen. We still look westwards for product leadership. You look at any large corporation, the largest product companies that have been built in India have imitated a Western model. So that's a fact. We have innovated internally. I mean, we have created great customized model. For example, hail an auto. Well, obviously, there is no auto in US, so how will you hail an auto there, right? But the taxi hailing service has come from the West.
Right.
And why does it happen? Because we don't encourage entrepreneurship in India as a society. So how do we expect bureaucrats to be supportive of it? Because see, somebody has a revenue job, somebody has the job of regulation, and your marks are for penalizing. You don't come in the news reports if you don't penalize a Vodafone, right? You come in the news report, Vodafone is penalized. What if you let them go, right? And as I was hearing Harish Salve recently, he said we have so many mini Anna Hazares in this country, right? What they do is that for any decision that a bureaucrat wants to take, you will sue him in the court and everything can be painted bad. So it means, to be honest, it doesn't impact, for example, my business or the company that I come from, because 99% of my business is outside India. It doesn't impact. But as an Indian, it doesn't give me great hope that we will be able to regulate. The intentions are right. I don't doubt the intentions. For example, my privacy, my children's privacy is very important. But how are you? Don't over-regulate. There has to be a balance. And similarly, there are business requirements. I come from the advertising industry. He comes from the software services product industry. He's developing products for GE. Everybody's requirements are different.
Right.
And unless if the regulator says, this is what is 1 inch and this is what is 1 inch, then you're dead. Right? You have to be flexible in interpreting it as a regulator. You have to be supportive of business, which unfortunately, I'm not saying that everybody is bad, but it's hard.
So in essence, what you're trying to say is that innovation is not a very consistent phenomena. Innovation that is pure Indian, right?
Yes.
We are able to build up a lot of structures, but those are on models that we have emulated from other countries.
See, we are great at innovating within those structures. But
Right.
creating a structure of our own, saying, okay, here is one product that went from India westwards. At least I can't remember an example.
Yeah.
Yeah, John.
Going back to your initial question, it was a technology and law question.
Yeah.
Most of us, including the debates we have had yesterday, today, most of it is looking at technology and law from a forward-looking perspective. We are all talking about a legislation which is not out there. A big underserved technology and law problem is where the intersections of technology and law with respect to existing legislation. And I'll take a few tangible examples. Let's take the example of additive manufacturing or 3D printing, more popularly known as 3D printing. If I print something in my lab, in my office, am I manufacturing? If I go with the traditional Factories Act definition of manufacturing, I would be manufacturing. If I do 3D printing, am I excisable, or now am I amenable to GST? If I go with the traditional definitions, I'm amenable to that. So technology and law, there are a lot of existing legislations which are impacting rapid growth of technology and innovation, especially in India, because these legislations have not defined the possibilities and applications of new technology as such. Another example is drones. We had a great project whereby we would be using drones for certain type of applications which are confidential in nature. But to do the research in India, we needed a particular type of drone, which we had to import. And it was impossible to import it, although we defined the law in a way that this will be used in this will not be used in Indian airspace, because there's a definition of Indian airspace and so on and so forth. We said we will create a controlled space within which this will fly, and so on and so forth. But end of the day, I can't even import this thing because the customs stops it at that level. I mean, I could always misdeclare it as a digital camera and import it, but which is something we don't want to do. And most drones imported into India is declared as a digital camera, and you can go under the radar if you declare it as a digital camera. So existing laws itself are stifling progress of technology, and progress of technology in the product space especially. And especially from the external counsel world, it's largely underserved. This technology and law space is underserved. Everyone is willing to look at data privacy, which is the sexy thing for the next couple of years. But there's a lot left to be done in the existing legislative space.
Preeti, we have been actually interacting or answering your first part of the question about interaction with the regulatory authorities. I personally had a chance of interacting with regulatory authorities in Europe for GDPR, and I also had a chance to interact with the regulatory authorities, not with respect to privacy, but in India. So I will say that in Europe, I had a very good response. For GDPR from European Regulatory Authority, the response was fast, and all the queries were answered, and to my satisfaction. But I couldn't say the same thing as far as my interaction with the regulatory authority in India is concerned. So I will say that in my experience, the experience in interacting with Europe was much easier. And for us, software is a disruptive, answering your second part. Software is a disruptive form, and it's always a challenge for us to, keep pace with the disruptive form that the software takes. So I have to take care of, IP for the respective, which the management or which the team wants to go ahead with the software. And I had to take care of the contracting, bringing required protection in the contracting. So, we have to keep also, I have to understand the technology that is disruptive in nature. So from the legal perspective, I had to keep pace with the software disruptive that is happening. So it's a big challenge. So constant interaction with the business team helps me in understanding the business, and also helps in understanding the protective framework that needs to be done for the software disruption that is planned ahead. So it is an interesting journey, and this journey is in progress.
Yeah, I mean, I think it is an interesting journey for everybody, because there are new things. It's not carved in stone. The possibility of bringing about evolution and sort of, interposing almost like a business thinking on the law, and also in your interactions with regulators also to try and get them to understand. That's important. I just want to go back to that one point that you were making about manufacturing. No, drones, I think we'll have that discussion outside. But just on that point, so I think the takeaway for me is that the ability of, the application of traditional laws to this particular space. So when we talk about manufacturing, typically, there's no manufacturing that is happening. But the interpretation of manufacturing, the way it has evolved and how it is different across different statutes itself, that by itself is a challenging task, right, in the tech space. I mean, who would think that for an R&D center, when you start thinking, like 5 years ago, I would not have thought, or 10 years ago, that concept would have been practically alien. So, there is this constant, I mean, how do you deal with such issues when these kind of questions come up, and lack of clarity across the spectrum of, different statutes?
So, we don't have a one-size-fits-all sort of strategy. Our approach to each of these problems is isolated to that problem itself. So, which is one of the reasons why we find it difficult to find good help outside.
Yeah.
Because if it's a recurring problem, there are people who will solve it for you. But if it's a one-time problem, people they haven't solved it before, they don't have the experience of having solved it before, and hence it's a one-time problem. So, in fact, I'll come back to the answer, but sometimes when we engage at that level with external counsel, what we do is we say, don't look at the time, give us a solution and do a value-based billing rather than a time-based billing, because it's a solution just for us, just for this specific problem. It's not a repetitive transactional sort of document or anything of that sort. So that's the approach we take. But coming back to it, there's no one-size-fits-all problem. So I'll take the example of additive manufacturing again. We decided we'll keep the number of people in the lab below the threshold to be defined as a factory, and we established an access control mechanism around it to be able to demonstrate that we would be that room was accessed by only so many people around the year, and so on and so forth. So we came up with some solutions like that, but it again is not a scalable solution. At some point, we want to have more than 20 people there. So it's not a scalable solution. For the time being, we found something, we are moving ahead. We work with regulators, we speak to them, but changing the Factories Act is almost an impossibility.
Yes, absolutely.
Yeah, going and negotiating or using policy. We have a strong policy department, and we engage with the government quite often, and we get a seat at almost every table. But in spite of that, changing something like a Factories Act is almost an impossibility. I personally have drafted a new definition of what would be manufacturing and the multiple definitions, and given it to a government affairs lead. who is constantly with the government saying that this should be the ideal definition of a factory today, and not what we already have in place. But for them, it's not priority. I mean, it's a problem affecting few, as opposed to their time is also precious. They prioritize it to solve bigger problems rather than an R&D center's problem. Although it's about time one looked at these kind of things, and otherwise R&D as an activity in India can scale to a different level had these issues been addressed. If we had this right legislation in place, we would have had 200 people employed on this by now. And it's below 20 now. We do research. We haven't scaled it up beyond a point because of that.
That's interesting. So this sort of leads me to segue into my third question, which is largely on dispute resolution. You know, we talk about the ambiguity in the law. We talk about the fact that perhaps there are people who don't necessarily understand it. How do you see dispute resolution shape up? With all of these, you know, the things that we've discussed just now, with this kind of a background, how do you see dispute resolution shaping up?
Dispute resolution, Preeti, I feel that is very dynamic, and in the coming years, we are going to see more and more of dispute resolution. The bankruptcy, IBC code, and many councils that have been formed. There is one extreme where we have a traditional dispute resolution form of typical lawyer judges who are legally qualified, and there is another extreme of councils like MSME and other, where you have civil servants as judges, and where they may not be legally qualified but are technically highly qualified to judge. So they may not have the legal wherewithal to understand the legal requirement on the one part on the council side, whereas on the other, traditionally the judge, where they do not have the technological understanding, where the pace at which the technology is developing, it becomes very difficult for the judges to keep pace with it. Of course, they have been taking various helps from the external committees also, where they try to understand the technology and give judgment. But that is always a secondary option. So I think going forward, we have to arrive at midway between these two extremes. And the High Court have been encouraging in alternate dispute resolutions. So with alternate dispute resolutions coming, I think the coming years we should see a lot of arbitration, mediation, and there should be more of discussion between the corporates to resolve the disputes than to jump to the courts to resolve it. So I think we are going to see a modern way of resolving disputes in the coming years.
Amit, do you agree with that perspective?
I am an optimist by nature, so I will keep the optimism. But I like children's books a lot, and my favorite book is Alice in Wonderland. And Lewis Carroll says there that the best start is from the start, best beginnings from the start. And I think in this particular case, you have to begin from the start, which is, first of all, the regulators have to train themselves. Particularly, I can talk about the privacy and data protection thing, because not because it's sexy, because it impacts us big time. In every country, we have problems. A simple data breach, for example, at InMobi, can trigger questions from multiple jurisdictions, and I know how many attorney generals I have dealt with. According to me, first thing is that we should find proper people who understand that law.
Yeah.
We are learning, they also have to learn, right? And then create a separate, faster forum. I am a big critic of procedural laws.
Yeah.
Procedural laws are a drain on businesses, people, and I think time is our currency. Procedural laws need a serious overhaul. And these type of specialized laws need simple procedures. Come to the point, talk about the point, and try and understand the business on which the law has to be applied. To his point, he was also saying the same thing.
Yeah.
If an inch is an inch, and you can't creatively interpret the law, then business is going to suffer. Right. So I think that is the way to go.
And within the existing framework, I'm a fan of arbitration to a large extent, and I'm a fan of ad hoc arbitration, not institutionalized arbitration. Maybe at a certain scale, I mean, I make this division in my mind that matters worth this much, ad hoc is better, and matters worth above this, maybe I will go institutional. And this liking for ad hoc arbitration is particularly because what Amit was saying, you have the chance of, you want the other person to know what they are dealing with. And in ad hoc arbitration, there is some amount of control if you play it right and can choose a panel in the right way. There is some amount of control of getting the right people who understand the subject matter, and a couple of other dimensions which are required to drive a particular outcome. It's possible to make it a controlled environment and have more control on the outcome in an ad hoc arbitration as opposed to even litigation. I mean, I would definitely avoid a district court in any part of India. So mediation, of course, it's in vogue, but I haven't really seen the benefits of a mediation process as such. So ad hoc arbitration is my single favorite for disputes of a certain scale.
So I have personally seen mediation play out really well.
Right.
I'm a big proponent of mediation personally, and our approach is to say that let that be your first point. To me, I think part of the fundamental challenge, because technology is evolving so rapidly, the laws may not necessarily keep pace with it, but even the judges, whether they are technical in nature, everybody may or may not necessarily understand what the issues are at stake. I completely endorse Amit's view that, the procedures are killing in this country when it comes to a dispute. Doesn't matter whether it's even in ad hoc arbitration. You may say ad hoc arbitration, you will still, and let's say it's our existing law. So whether we like it or not, and if you have retired judges as arbitrators, then you would typically, notwithstanding the express bar of exclusion of Evidence Act and exclusion of CPC, by sheer habit, because that is what they are accustomed to, they follow that. So I think, just in terms of the whole purpose of arbitration, ad hoc or institutional, gets defeated if you are looking at it from, following our protracted processes. And having a specialized forum that will actually be dealing only with this, I think there is so much merit. I mean, I would completely support something like that. I think that's something for us to think about, because our tech disputes, in times to come, they will also evolve in terms of their degree of sophistication, in terms of the degree of issues, and there'll be a whole global perspective to it as well. So if we want, even in India, to sort of bring that as a business into India, that dispute business into India, then also we have to think about the changes that we have to bring in this. We don't have a lot of time left, but I do have one last question, which is simply put on law tech. We are talking about how we can help general counsels and businesses become more compliant. How do you see tech law or law tech playing up in the current environment? Yeah, sure.
Okay. See, I am a lazy person by nature, and I enjoy not working and still getting paid. So if my computer can do what I do, I'll be the happiest person. And I encourage any kind of artificial intelligence. In fact, my annual assessment of my team always is as to what is the value add that you're bringing to the table. There is no value add in saying that I did 600 contracts in this year. What is the value add that you brought to the business? What is it that you did new? And for that, you need to free up your time. See, legal functions, particularly in-house, means on the other side of the audience, you're always overstaffed because you want to keep a bench to take on new clients. We have the reverse problem. We are always understaffed, so that we are already a cost center, and I don't want the CEO to looking at me and saying, "Man, two people too much." So I welcome artificial intelligence. We are all about innovation. I would like my NDA is first example, first step to be done by a machine. Why not? And we have so much complexity in this world, and particularly on the technology side, that a legal brain will always be engaged. I'm a firm believer of it. And a change which has to come, whose time has come, cannot be stopped. So there is no point. For example, I do not understand why do foreign publications don't come to India, or why do foreign law firms don't come to India. I mean, are we scared?
Yeah.
Is my mind less than the mind of a Western lawyer? No. Why? I think that this protectionism, etc., doesn't work at a great level. I welcome Morrison Foster to Bangalore. It'll be great. So the same thing is with artificial intelligence. I think nobody has to be scared of it. Because the value that a lawyer brings on the table is thinking on the feet, understanding the law, and applying it to facts. That human brain thingy can never be taken away. And if you look at any kind of artificial intelligence today, is all nothing but glorified search. Think about any artificial intelligence. The format of search has changed. You ask Alexa, I want to listen to Kenny G. Right? It will just go look at an index, pick up Kenny G. It doesn't know what song. I want to listen to a sad song. It will bring the most peppiest song on the planet up. Right? Because it doesn't have that human intelligence. The time of IQ is gone. Right? It's time for that emotional intelligence, and lawyers, by nature are creative.
Yeah, I agree to some extent with Amit. We are also quite understaffed, so artificial intelligence is most welcome in Ramco. But I am also a firm believer that artificial intelligence cannot completely wipe out the legal brain.
That's right.
So maybe a lawyer with artificial intelligence will be able to do the work of a 10 lawyer. Maybe that is possible. So we can free our time for next higher level of utilization and grow ourselves to the next level. So I think we should embrace artificial intelligence and use it to grow ourselves. So artificial intelligence is here to stay, is most welcome, and will not completely eradicate the legal brain.
My wish list is AI which can predict the outcome of a case.
Yeah.
If I can feed in all the data and say this is the direction it will head, yeah, that would be my most recent. I don't know whether it will remain wish list. It could play out very soon.
So I'm being told the time is up. I do want to raise. Do we have time for a couple of questions from the audience? Then maybe we can do it outside. But I really want to thank all of you. I think, in essence, everybody is in agreement that there has to be clarity in the law. No point in having the law without clarity. Dispute resolution, we need to have faster processes, a separate forum, and use of AI is irreversible. In essence. Thank you very much. Thank you very much to the audience as well for listening in. And sorry, we are not able to ask any questions, but we will take them outside if you wish to discuss anything further.
Yeah,
thank you.
And thank you, Preeti. Thank you for moderating the panel. It was really well. Until AI doesn't come, law firms exist. So we are happy to help. On that note, a little something from my law.
Thank you.
Thanks so much. Thank you so much.